Right, so here, look, exactly as I taught myself, right, before I even bought this book, before I even bought the book by the professionals, right, in the Human Rights Act, when I actually read and learned this act, in section 7, 1B, right, sorry, section 6 it is, right, 6.1. I'm right, look here, and section 7.1. It's talking about section 6 in relation to section 7.1 and 7.1b, which means when you've got an unlawful act against you, right? But it's talking in relation exactly, right? This is the only part in this book where this appears about section 7.1b, right? Section 7.1b is when you're the victim of an unlawful act, right? And you can rely on a right in any proceedings at all, right? But they've got it. It only appears in this book when the authorities are acting against you unlawfully, right? But that's mainly to do with proceedings and procedure. So this is before 2005, right? In 2005, we got the criminal procedure rules and civil procedure rules, which had the overriding objectives, right? You've got to recognise the rights of the defendant and the needs of other cases. We got, in 2005, the override objectives D and HIV, right? For example. Now, in 1998, right, we didn't have the criminal procedure rules, and there wasn't a requirement to recognise the needs of other cases and the rights of the defendant in every single case that goes through the courts. So it doesn't... They put that in the criminal procedure rules because it applies to every single case, right? Every single defendant in every single case has to be evaluated under overriding objectives. Unlike, for example, under the Public Order Act 1936, if there was anyone using political rights and got arrested at a protest, then they meant to have an assessment by the Attorney General or Chief of Police, right? Because they might be using rights then. But that was before the Human Rights Act. Now, the Human Rights Act, you can be a victim of an unlawful act by the police or authorities, right? Now, the right to petition is English law, right? It is a law. It is a law in England. The law of England is that if you are petitioning, right, either Houses of Parliament or the King, if you get prosecuted, it's illegal. It's a crime in England. Now, you don't say, oh, it's got nothing to do with, EU law swept it away. How has it? It's an English offence. It's a crime in England, just like any other crime, Criminal Damage Act crime, or assault or something like that. You don't say, oh no, we don't have an assaults anymore in England, right? It's a criminal offence. You are the victim of an unlawful act if you get prosecuted by the police, right? The only thing is that no one knows about it because only Parliament can hear that particular offence. It's a contempt offence. If you get prosecuted illegally when you're petitioning, what is the offence? It's a contempt offence. It is a contempt offence, misconduct against petitioners in the law of Parliament. I actually don't think that Mark Elliot has read Erskine May. I don't think that he's read and studied the Erskine May books, right? And the new ones, it's still in there, but it's just like summarised, right? They don't go into as much detail. It's not that the law's changed, because you don't change the law of Parliament, right? The law of Parliament is law of Parliament. It's based on standing orders and tradition, right? So, like, you ought to read different editions, focus on different areas of parliamentary law and elaborate on them depending on who the author was and which their particular interest was. It's not that law's necessarily changed. Sometimes it does change, right? But not for this, right? Because it is what it is. Now, this is before The 2005 criminal procedure rules required every single defendant, right, to be assessed to recognise their rights and the needs of other cases, if there were any, right, because you got overlap of jurisdictions and conflict of cases being held at the same time in different courts and things like that, right? It's required after 2005. It's actually the law, right? So if you don't recognise the rights of the defendant, right, you're breaking the procedure rules. Now, this is 1998. If you appear in court and the court or the prosecutor or the police or any other party makes a crime against you, right, you're the victim of an unlawful act and you can rely on your rights in absolutely any proceedings. This is linked into, like, when you've got the right, when you're ill, right? When you're ill and you can't attend or something like that, right? They've got to recognise it, because otherwise they're encroaching on your rights. And this is why you can rely on the right of an injury in any proceedings at all, even probation proceedings. That's why they actually go in there, right? Because if they make you work when you're ill and you can't work, that's an unlawful act against your rights as well. Or if they make you go into court when you're not fit to attend, right, that's an unlawful act as well. And these are like this is sort of like, it's like a precursor to the overriding objectives of the criminal procedure rules, but before they made them, because this is 1998, before 2005. Now, that section is exactly how this section here, I intuited it, and then when I read this book, it's basically exactly the same, because ways of using section 6.1 against public authorities. Now, this is the thing, right? This is where Mark Elliot, I think, has lost the plot, right? And I'm not saying he's not intelligent, right? But he hasn't learned it properly from the start, this area of law, and he doesn't understand it properly, right? The police are a public authority, right? The Crown Prosecution Service are a public authority. The court are a public authority. The fire brigade are a public authority, right? Now, you can be a victim of an unlawful act by those public authorities, particularly, for example, if they don't recognise your rights in procedure and proceedings, like, for example, if you're ill or something like that, right? But this is the thing. When we take up the right to petition, okay, and we are doing usage of Parliament, according to Erskine May, because when you're making the usage of Parliament, you're either pursuing a bill or petition or something being put to Parliament, or you're representing something that someone's already doing to it, right? Like if they've already got a cause that you're promoting, right? An existing cause to Parliament that you're promoting it, right? But you didn't start it, but you're canvassing it for them, right? You're not acting as a public authority. So under human rights, when unlawful acts by the public authorities, right, what Mark Elliot is probably trying to make out, right, by the Supreme Court is that somehow that if you do an unlawful act, then you're liable like the public authorities are, but you're not acting as a public authority. You aren't acting as a public authority. In section 6.6, acts of the public authorities except pursuing bills and matters to Parliament, which is not an act of a public authority because you are not acting as a public authority, right? Like if you were doing private prosecution, right? You're using authority on behalf of the public, right? But privately, not like the services that we pay for. But when you bring a civil case and you're using legal professional privilege because you're making use out of the public authority. You're making usage out of the public authority of the court, right? You are using a court, usage of the magistrate's court. So you're using a public authority, right? And you're bringing a case or to the county court. You're engaged in the usage of the county court, right? Which is a public authority, right? So it still acts under and through the public authority. The police are a public authority in criminal cases to the magistrate's court. The Crown Prosecution Service are. The fire brigade are, right? This is what it teaches you. Now, when you're using Parliament, and this EU law does not affect this because this is a Human Rights Act, which is the whole point. When you're using Parliament, it's not a public authority. It's separate because you're not using the common law that the public authorities use. You're engaging in usage of the law of Parliament, which has its own distinct law, right? And some of that is used in election campaigns, right? An election law, because it's still a parliamentary process, but special law was made, a lot of legislation was made in the common law to accommodate for it, like in the Representation of the People Act, right? But it was fully under the parliamentary law. Now, the right to petition did have common law for it with the Tumultuous Petitioning Act, right? It had some laws that regulated it, but that's been repealed in 1986, right? The Tumultuous Petitioning Act. So it doesn't have a regulation now. It was a little bit like election law was purely under the law of Parliament, but then it got put under the law of the courts after 1868. The right to petition did get put under the common law for consent requirement from 1661 till 1986, but then it's been repealed. The election law history, actually, it was the King and Council who dealt with it, but then they started having the assizes deal with it, but then Parliament decided that it was actually privileged only to Parliament, and then it went into parliamentary law through the 1600s and the 1700s, and most of the 1800s until 1868, and then it went back to the courts jurisdiction again. So that jurisdiction had been moved between the law of Parliament and the common law, right? But this is the thing. What they're trying to make out, right, are these people like this Mark Elliot, right, Professor Mark Elliot. They're trying to make out that, European law has nearly swept this convention away. But who's decided that? Oh, apparently the Supreme Court. But the Supreme Court can't decide that, right? They don't have the power or authority to, because it's only got appeal-like jurisdiction instead of the House of Lords, right? Now, this is the problem. In England, we've got laws, right? We have laws in England, like, assault, right? Now, one of the laws, for example, let's say obscene publications, right? What is the law? Look, right, the law for obscene publications is that if it's for the public good, right, it's not an offence. There is no crime. If it's for the public good, you aren't committing a crime. Now, EU law doesn't say, oh, well, you might show someone an obscene thing and, they might be victims, so therefore, they've got a right or whatever. Look, right, the offence is created in England. Europe didn't create the offence, the crime, right? What's it got to do with... An offence has been created in England. Shall we ban smoking or allow it? Look, right, the crime is invented in England, obscene publications. The law is that if it's for the public good, it's not a criminal offence, right? Now, you say, oh, you have to go into a court and argue it's for the public good. Look, if it's for the public good, the officer doesn't charge you because the law says that it's not a crime. Now, what is public good? Why is that? Why make the law around that? Because things like charities, right, have to show things sometimes that are obscene, right? Like, for example, animal cruelty and things like that in order to raise awareness of it, right? So it's not a crime, or else they can't raise awareness of it. They've accommodated for it in the law, so it's possible to do it for certain things that need to be able to do it, right? It's accommodated for in the common law. So they're going around doing things that otherwise would be obscene and offend people. Where's your right to remedy there? Well, look, it's not an offence because people need to do that. Now, the right to petition says that you've got the right to do it without being prosecuted. To prosecute you is a crime. It's the law. It's not swept away. It's in force, right? Now, when you are doing matters and causes to Parliament, it's for the public good because the public sign the petitions. You're doing it on behalf of the public at large or a section of the public, right? To publish in parliamentary law and in referendum law, right, means to make available to the public at large or a section of the public in whatever form and by whatever means, right? So you don't have to have every single person supporting it in the public, just a section of the public, right, who think it's an important matter, right? And that you don't even have to use the right to petition for that. It can be a charity. What's that got to do with EU law, right? You can do it when you're petitioning because they can't stop you from doing it because it's illegal to prosecute you, right? And when you're a charity, it's not illegal to prosecute you, but you can't be prosecuted anyway because it's not an offence, right? Now, what's Mark Elliot going to say? Oh, well, the person who's having to look at obscene things has got a right to, a right to what? The other person hasn't committed an offence because in law, it's not a crime, right? This is the thing, not criminally, Now, for civil law and tort, Mark Elliot might say, oh, that person was offended and he's upset and he wants to sue the person, but they're not prosecuting them criminally. This is the thing. And the 1689 Claim of Right Act from 1689, you can't use protections for civil debt, right? So no one is actually arguing with Mark Elliot whether or not someone can bring a civil suit for money damages against petitioners, right? But all that's accommodated into the law once you read it in English law, like under all the Right Acts and so forth, and even under the Criminal Damage Act merged, and it says this in the debate, right? It says this in the Parliament debate on the Criminal Damage Act. It says, right, they're merging the civil liability for the monies to damage and they're merging the criminal aspect into one act, right? But you haven't committed the crime if you've got a lawful excuse, right? So it's applying the exemption on both circumstances. But if you do make the crime, you've got some liability for civil debt. It's actually, and you can use privilege on private land and on public land and public property, right? Because it's owned by the taxpayer, right? So if you do criminal damage on public land or public property, it's owned by the taxpayer, by all of us, right? And you're not liable to civil debt for that because it's not privately owned. So you don't have a plaintiff, right, who wants to claim Mr. Smith against Mr. Johnson, right, that he owes him some money because it's owned by all of the public, right? And it's clear. It says that you can use privilege on public land and public property, right, publicly owned, which is exactly like the same. This is intimately connected and based on and around the First Right Act, right? I think it's the 1715 one, which is in itself based on the Tumultuous Petitioning Act, right? And the Criminal Damage Act figures in privilege into it. The reason why it's figured into it is because also you've got the Control of Advertisements 2007 and earlier, which anything on the surface of anything, right? When police bring criminal damage charges, They shouldn't be, and they don't have poetic license. If it's surface damage and defacement, right, it's in law, the definition has legally been removed from criminal damage, right? It's defacement if it's on the surfaces, right? And it's a fine by the council. It's not for the police, but the police like to put it through as criminal damage because they think they've got poetic license, but they don't. They're just thick, right? And they've not been trained properly at police college, right? Surface damage is reclassified. It's not criminal damage, right? And I don't actually, and I think that 2007 Act goes back quite a way before then, because I thought it was brand new in 2007, but it actually goes back a lot earlier to the 1980s, and possibly even, I've forgotten, but I've got it on these pages somewhere here, it goes back nearly as far as the Criminal Damage Act, right? The council deal with surfaces on public owned property, right, in town centres and in the streets, right? And all that is fines, but you've got your Class F, which is where you can apply, you're allowed to apply any act, which is a 1688 Bill of Rights, which is you can't be prosecuted, which is your exemption, right? It's made for it in English law, plain and clear, right? A law, just like obviously in publications, it's the law if it's the public good. There is no offence, there's no crime, right? It's got nothing to do with EU law. EU law doesn't... The Europeans aren't writing our law. What's the point in having Parliament to enact law? We're making laws in England, right? We're writing the law in England. This is what it is, right? Now, control of advertisements has specifically got Class E and F for elections and other things. This is when you can bring other acts and legislation in, like the 1688 Bill of Rights, and apply the provisions directly. You cannot be prosecuted, right, for using parliamentary material. Why? Because it's the law of Parliament, and it's a crime to be prosecuted, and it's not being done under the common law. They've accommodated for it in the control of advertisements, because one of the prime and main things that you ever do in political campaigns is use advertising material, right? And the criminal damage part, right? If you say, well, it's surface damage, you don't need deemed or express consent, right? You're exempted for it in Class F. Now, that's for attaching advertisements, and it includes putting screws and nails in, anything that you're allowed to do, because when you get deemed an express consent, right, you're allowed to do it because you got permission. So therefore, what we're dealing with under the control of advertisements is the installation and removal and maintenance of advertisements and anything that qualifies under that usage. So it says installation of adverts. Everything that is required to install an advertisement, if you have got permission, right, or if you don't need permission, you're exempt from permission, right, is covered in the Act. So it extends to nail screws and glue and things like that, right, which is, it's disqualified from being criminal damage. And even if it was, when it's on, you've got the privilege. The 2007 Control of Advertisements Act gives you the privilege of using those screws and stuff, either if you've got consent and permission, or if you're exempt from having consent or permission, right? Particularly because it's dealing with public land and public property, which is where your lawful excuse is with privilege in the Criminal Damage Act. So it can't be criminal damage anyway. If the Criminal Damage Act was not compatible with the 2007 Control of Advertisements, you'd have problems, right? It's just, I don't think that Mark Elliot has been teaching this to this extent and understanding, right? He's not. He doesn't actually have a full, complete concept of all of the compatibility and interactions between all the acts, right? How they all actually work like cogs in a machine, right? And it's actually, someone's actually gone out of the way to do that. MPs, people who know what they're doing. And I actually don't think that Mark Elliot has a deep understanding of it. Like, there's always some MPs who know what's going on, and regardless of what members of Parliament don't like these particular rights, they always manage to get certain clauses in and get things through that make it compatible, and then you've got John Tinker in the 1944 Petitions Committee report reminding us about, the right to present a petition without any MP signing it, in a judicial matter, which is usually if your privileges have been invaded on, right? 2007, they know what they were doing. I don't. The problem with these professors is they've got good memories, right? They can read a book and memorise it. They can just reel it off, right? And then if they can reel all these books off and remember everything, they pass the qualification. That's not showing a working understanding in how the machinery of it all works together and is compatible, including with our rights in the Constitution, which clearly is made in Section 6.6 of the Human Rights Act, right? And in loads of legislation, there are acts that don't mention it. But even when you get into driving, like, you've got special reasons why not to convict, or special reasons why not to, give a sentence or punishment. It's got special reasons in it in a lot of the Highways Acts. The Bankruptcy Act is the act which explicitly shows that you're forbidden to use privileges in English law, right? That's the law. If all this had been swept away under EU law, I don't know how the hell they had Lord Hanningfield case, and they didn't even get that right. Jeremy Johnson did not even get that right, but they still put it through. So I'd like to ask the Professor, right, when he's publishing his new book on the Constitution, right, it must be an enigma how they got Lord Hanningfield's case through, because Alistair McReef made the order and judgment. So I don't know how he's going on with his Supreme Court judgment on that it's been swept away by EU law, because it was only in 2011, right? So how did he get that case through? This is the thing. There's gaps. There are gaps in these people's knowledge and understanding, and I'm concerned about it. And this is why when you go to barristers and you go to solicitors, like, oh, I don't want to do it, right? They won't do it. They don't believe in it. Mark Elliot does not believe in the Constitution of this country that we're in, but it's law. You don't sweep it away till it's repealed, right? The Supreme Court make judgments in the common law of England where they've got the jurisdiction to do it. They're a public authority. Even the Supreme Court, right, are meant to be only a public authority and up to the appealite jurisdiction. It's not the court of origin, right? And you aren't appealing to the Supreme Court. And you can only appeal if you're the plaintiff or the claimant, not if you're a respondent, right? And I really don't know what the hell Sarah Putchin was doing in that election petition with Graham Moore when she was said it and didn't fill the forms in properly. That was a matter put before the court that heard the case, and they actually let it go. And then she was sort of like challenging it or appealing it. Actually, it says that for election petitions, there isn't actually an appeal. It's not an appeal. It's more like a judicial review, right? And you're meant to have that after the case is finished, not when you just started it, which is kind of ridiculous. There were a lot of issues around the election petitions, and in fact, the costs can be absorbed by the public, right? So I don't even know what Sarah Putchin was doing with that. Nigel Farage is bringing a case to the Supreme Court now about Parliament calling the elections off, which is absolutely scandalous and ridiculous, because the courts have only specially been given the power to hear a controverted election. If someone contests the outcome of an election, they were they had to be particularly given this power through legislation because it was privileged only to Parliament, right? After 1868, it's deprivileging it, right, through legislation and allowing the courts to hear it. But that's not whether you can or cannot have an election. That's privileged to Parliament and the Secretary of State, right, because they're an MP. And I don't really know why the Supreme Court is entertaining a lot of those cases. It's actually ridiculous. There's something very strange going on, and it's to do with a lot of misunderstanding. And Nigel Farage is he completely cheated in his own election campaign by using that Talking Pints programme when he knew that he was going to be standing in the contest and he knew that it was going to be affecting his popularity. No one had the £5,000 to challenge it, right? He's a cheat. And I don't know what lawyers that he's, Noel Wilcox, he had a county court order for illegal ULEZ and LES signs, and he went to the High Court to get an order, and they wouldn't hear his case, even though that the county court had backed him up. They wouldn't hear it. They wouldn't even want to hear his case, right? So I don't know how Nigel Farage is getting these preposterous cases at the High Court allowed to be heard, which is just scandalous and ridiculous. But that's another matter of his elections. We're talking about the right to petition. You need... Look, right, Mark Elliot, I don't think that he knows the importance of or has studied the observation of due process of law, right, which is a really important act. That is petitioning the king, right? Because how has that been swept away by EU law? Look, right, if the observation of due process of law, right, has been swept away by EU law, how can they have e-petitions? They can't legally exist, right? You can't have e-petitions, and you can't even have petitions to Parliament. So that would mean that standing orders of Parliament don't work. But Parliament makes standing orders of Parliament up, not the EU. Does the European Union write the standing orders of the House of Commons? Riddle me that. Mark Elliot thinks that the European Union write standing orders of Parliament, right? You got to be kidding me. So how can the observation of due process of law not exist? It's an act of law which legislates on the usage of Parliament, right? And the King in Council petitions to His Majesty's government. And you're not allowed to make arrests, right, unless you have got an official matter of record and writ, right? And I'm not actually 100% certain whether you have to get a warrant from Parliament, like, to get the Sergeant at Arms. But people were abusing the usage of Parliament, right? And they were like getting lynching mobs, or not lynching mobs, but they were apprehending people, and they weren't going about setting it in writing or getting warrants and things like that, and they were just grabbing people, and they were claiming that they were arresting them or detaining them under the jurisdiction authority of Parliament, or I don't know whether they were taking them off to London in a cart or in some kind of the child catcher cart or what, or on horseback or what, but they made a law so you can't actually make arrests under the authority and jurisdiction of Parliament, right, unless you've got a matter of record, right? So I don't know whether you've got to set it in writing, and if you write the petition then it qualifies, or if it meant that you can't just go arresting people and taking them to Parliament unless you submit the petition and you get a warrant or whatever, like the committee, have to summon people through the power to summon persons, papers and documents, right? But people were arresting people in the usage and authority of Parliament, and they were abusing the process. So that's why, really, we don't go around like a private prosecutor does, making citizens' arrests on people when we're doing petitions to Parliament, right? It's got something to do with the observation of due process in 68, right? Now, that's what the professor should be. He should be researching that, and he should be learning about that, right? That's what he should be interested in and teaching people. which is what they should be teaching on the constitutional law course, right? They should be teaching that on the constitutional law course, and then on the history of England courses as well at university. But the 1688 Bill of Rights is really important because all these jurisdictions exist. All these jurisdictions are a thing. All these jurisdictions are a court of legal process and law, which is distinctly different and always has been from the normal courts and the common law. The 1688 Bill of Rights just makes certain clarification and affirmations on certain things in those processes. I mean, really, Article 9 of the Bill of Rights is not actually that important or notable when you've got Strode's Act, because Strode's Act already made that in law, right? But they're bringing it all together in one act. They're bringing all of the principles. Really, all of the 1688 Bill of Rights is really, it's not just Article 9. You know, free speech in what? Matters and causes to Parliament, casework to Parliament, the usage of Parliament, using the jurisdiction of Parliament, right? EU law has not removed the jurisdiction of Parliament. I mean, they've even got the European Parliament, which, you know, is an insult to us to claim that all these if it's enacted and if it's in force, it is the law. I really don't know where Elliot's got his, you know, swept away thing from, and he's actually putting this in books, which I think is contempt of Parliament. We can't get these people prosecuted because they've got to be, if they're breaking the law of Parliament and misleading people on their political rights is a contempt of Parliament. It's misconduct against petitioners, right? That's a crime. Now, Parliament are not summoning anyone in. They're not even letting us, they won't action any petitions to summon people into Parliament. They won't call the police in when they've arrested people illegally. They won't call the prosecutors in. Patrick Gibbs, it was proved that he breached the privilege of the House of Lords. Was he called in to answer? Was he summoned in on contempt? No, they didn't do it. The courts can't hear contempt of Parliament, right? It's got to be heard by Parliament. This is what the John Hatzel book is full of, these cases, right? Parliament just aren't bothering to use it, and they say, we've set up the, Culture, Media and Sport committee, they can deal with contempt. Why aren't they calling YouTube in Neil Mohan, when he's taking down people's political material? I'm very concerned about Mark Elliot, right? Because I just don't think that he's misteaching people, right? He's erroneous. He's in error. He's not only. It's not like he's. If he was just not teaching people as well as he should, that's one thing. But misteaching people, right? That is, it's quite serious.